Hello, everyone. Welcome to our YouTube channel. Thank you for joining us here at the Fulgham Law Firm. I'm Jeff Hampton with the Fulgham Law Firm, and I want to talk to you today on our YouTube channel specifically about theft charges in Texas. How does a misdemeanor theft become a felony theft, and how can a felony theft be dropped down to a misdemeanor theft? Thanks for joining us. By the way, if you wait around to the end of this video, I'll also give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. All right, let's jump right into this. Now, here's the thing. Theft is one of the most commonly prosecuted crimes in the criminal courts of North Texas. You'll find that people are arrested for this all the time. I mean, you've got it anywhere between shoplifting to, white collar theft type examples of theft that's out there today. But also, I want you to understand theft is also one of those offenses that can be the most damaging to someone's credibility and their career if it is not handled properly. You want to make sure that you or your loved one's theft case is handled in a way where you can ultimately have it removed from your criminal record. So we're going to talk about a very important distinction today when we look at Texas theft charges. How do we know whether or not it's going to be a misdemeanor or a felony theft? And is there anything that we can do to affect that? So first, let's define what theft is, okay? So Texas law defines theft as being when an individual, quote, unlawfully appropriates property with the intent to deprive the owner of said property. Essentially, you commit theft when you take something that doesn't belong to you and you did not have the consent to do so or other justification for taking that property, okay? So, listen, everyone has a pretty good idea of what theft is, and I'm going to give you some examples. We know shoplifting, that's an example of theft. There can also be auto theft, the stealing of a vehicle, right? Which there's no specific, people think of grand theft auto. There is no charge for grand theft auto in Texas. It's just categorized under theft, okay? And then there's derivatives of theft-based offenses like credit card abuse and different things like that. But we're going to focus specifically on just the crime of theft. Now, how do we know whether or not a theft charge can be a felony or a misdemeanor? Well, I'm going to give you a very simple rule. If the amount involved is $2,500 or less, you're talking about a misdemeanor charge. Okay. So as an example, if it's $100 or less, if you're talking about $100 or less, that is a Class C misdemeanor, which means it's punishable by fine only, no jail time. Okay. However, you still don't want to just go pay that fine. You go pay that fine at your municipal court, you've admitted to guilt and it's now a conviction on your record. All right. Now there's a Class B misdemeanor theft. The value of that is $100 up to $750. So between $100 and $750, you're now talking about a Class B misdemeanor, which is punishable by up to a $2,000 fine and up to 180 days in jail. Okay, that's the range of punishment on that. Well, what if you get above that? What if you get over $750 up to $2,500? Now you're talking about a Class A misdemeanor, punishable by up to a year in county jail and up to a $4,000 fine. Now, if you get above $2,500, you're in felony land. You're talking about every charge above $2,500 is going to be at least a state jail felony or above. And those amounts, the higher the amount of the value of the items that were taken, allegedly taken, the higher the level of offense. State jail, third-degree felony, second-degree felony, first-degree felony. So it's all based on value. So now all bets are off if you or a loved one has a prior conviction for theft. So if there have been prior convictions, the craziest example that I've seen is I've literally seen someone steal something less than $10 worth. You're talking about at the 5 and dime store, literally. They take $8 worth of something, but they have 2 prior theft convictions. They are now still looking at a charge, literally a felony theft of up to 2 years in prison for $8 of something taken, okay? That's an extreme example, but the law does that. It begins to punish you at a much greater degree if you have prior theft convictions. That's why you cannot take a conviction to a theft charge, okay? You just can't do that. You got to make sure it's handled in a way where you can get it off your record. So very simple, how does a felony theft charge get dropped down to a misdemeanor theft charge? There's several different ways. One can be based upon the value. If it determines, we've had this happen many times. Let's say you're looking at a situation and we're able to see that the alleged victim claims a value of an item. I had a guy one time that claimed his car was worth $3,000 and it wouldn't even start. It was not worth $3,000. So after we took a look at it, we were able to determine that the actual value of the vehicle was less. And I'm talking about like an old beater, like a 25-year-old car. And they literally were claiming it was worth $3,000. Once we got an estimate of it being worth more like in the range of $1,800, you're no longer looking at a felony theft charge. If the state of Texas cannot prove value beyond a reasonable doubt, they don't have a felony theft case, okay? So that's one example, is to get it dropped based upon the value. The second way to do it is through negotiation. Sometimes your attorney, even if the value is higher and it does categorize under a felony, sometimes even if the individual did actually commit the crime, your attorney may be able to negotiate with a restitution. If restitution is provided, sometimes that attorney may be able to negotiate a resolution where a felony case is dropped down to a misdemeanor case, or sometimes even dropped down to a possible dismissal based upon that restitution being provided. And so we've had that happen several times here at our law firm. And so it's something important that you look into. Okay, so listen, this is the reason why it matters. You say, well, why do we care if it's a felony theft or a misdemeanor theft? Because obviously felony theft involves higher penalties, and you're talking about potentially being a convicted felon if it's not handled properly. No longer can vote, no longer can possess a firearm. It's going to affect you from being able to get a job in the future. So each and every one of these is very important to take a look at because of the severe consequences that could result from a case not being properly negotiated and fought in court. So that's just a short example of what you're looking at. Maybe you or a loved one is facing a theft charge in Texas. And if you would like, feel free to contact the Fulgham Law Firm for a free consultation at 817-877-3030. I promised you if you waited around to the end of this video, I would give you a free ebook, What to Do If You Have Been Charged with a Crime in Texas. Click the link below and we'll be happy to send it over to you. Thanks again for joining us. Look forward to seeing you on our next video.